Let's listen to Pavarotti.
Hello, welcome to The Revealing. I'm your host Pavarotti, and I'm here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes. These are my opinions, not here to slander. I will provide information, give you my opinion on the information I provide. My opinion's mine alone. In this episode, I think I'm going to be able to prove beyond a shadow of a doubt that the defense is asserting that there is a confidential informant in the Bryan Kohberger case. And I'm going to do that via the motion to suppress for the Amazon warrant. I'm on that one now. It's beyond me how people can go through some of these suppression motions and come up with the conclusions that they come up with. Beyond me. In fact, before we get into it, I'm just going to have to do a little talking for a minute. Because I've tried to watch some other content here the last few days, even going as far as watching some opposing views because they have catchy thumbnails. And I watched one guy for about 15 minutes that used to cover this case, hasn't covered it for a long time. Now he jumped back in with his 2 cents, and this moron goes through the PCA like it is still factual today. I mean, even as far as going through the WSU officers finding the Elantra on November 29th, like it's just a fact. I mean, he hasn't watched any of the court proceedings. He hasn't done any more investigating into the case, but he wants to throw his 2 cents back in and bring up that old dead information and then talk to people like, they're stupid for not believing what he says. He is a moron. Then I'll watch another one that actually, I come to similar conclusions as he does on some things, but for completely different reasons. But, again, just blinded by the light. And I knew it was going to happen. I knew the guilters out there would start using motions to suppress evidence as reasons for guilt. So I had to look at one where now he's certain that they found DNA of the victims in the Elantra, and that's why they're wanting to suppress the evidence. Freaking ridiculous, absolutely ridiculous. They didn't find any evidence of DNA in the Elantras. That's not why they want it suppressed. Let me explain something to you about these motions to suppress. And it even explains one enigma that I have been, and those of you that have followed me know that I've been very outspoken about for quite some time. Okay, so the reasons for wanting every one of these items suppressed is because the state's case against Bryan Kohberger, even acknowledged by some of the guilters out there, is a very weak case as far as evidence against Bryan Kohberger. The evidence that they're going to try to use at trial is called circumstantial evidence. And it's amazing to me in society today what we allow into the courtroom as circumstantial evidence. As some of these investigators so-called build their cases, they use the most vague of things to build a case with as far as their circumstantial evidence. So, for example, when you get into some of these motions to suppress, you'll see things like, for instance, why would he want the Elantra search suppressed? Why would he want his apartment search suppressed? Well, I can tell you, when you look at what was gathered from the Elantra and you see things like nitrile gloves, a shovel, those are things that have no intrinsic value as far as evidence in the case. However, at trial, being able to present all of the circumstantial evidence, they will use something as unassuming as the fact that he had gloves in his vehicle and a shovel. They will use little things like that as circumstantial evidence to paint a picture of their case. Yeah, we've seen it in the Richard Allen trial, the things that they were using as evidence against him that wasn't evidence at all. So everything that the defense can get suppressed is less BS circumstantial evidence that the prosecution can use to paint a picture in this trial. Then you get into all of the digital information. Remember that the defense has a Mount Everest amount of discovery to go through, most of it digital information. Well, I want you to think about it for just a minute, because when you start to read through a lot of these motions to suppress, you'll see that companies like Amazon, Apple, Google, they actually keep an enormous amount of information on you. And the information that they keep tells a lot about you, your lifestyle, who you know, what you like, what you look at. And when you're talking about a circumstantial case, inferring any information from things like that could be used to paint a picture. It's basically it's the old saying, you show me the person and I'll find you the crime. Well, it's you show me the person, give me enough information about them, and I'll pick out and cherry pick things to paint a picture of the crime. It's basically what we're dealing with here. So getting all of that information suppressed is less BS that the prosecution can use to build a case. For another example, like in some of the digital aspects in the motions to suppress, one argument is the fact that Kohberger may have wanted to beat somebody up a couple of years prior to the atrocity or 5 years prior to the atrocity. The defense is arguing how that is immaterial to the case, and it most certainly is. But see, even little things like that, the prosecution can say, look, we found an old email or text message or something that was written down in one of his notes that he was very upset with somebody and he wanted to beat them up. That shows a propensity to violence. That's the kind of crap that they will try to pull at this trial. So yes, they want to get everything they can suppressed so that the BS stays out of the trial. And they have every right to do that, as I'm going to show you as we go through this Amazon warrant. I think it will open your eyes to things. And if your eyes were already open to them, but for some reason morons out there that you listen to have kind of made those eyes shut a little bit more, we're going to open them back wide open in this one. And the Amazon warrant is an easy way to do it. But the other thing that all of this has enlightened me on, for those of you that have watched me for a while, I have been adamant about wanting the rest of Bryan Kohberger's alibi statement. Not because I want to prove his guilt, but because I want to verify what I have investigated as the night of the atrocity progressed. And I need the rest of his alibi statement to do that. But now when you think about it, because of what the defense has in their possession to be able to get all of these things suppressed. Really, really smart move by Ann Taylor to hold back that alibi until this point in time. They let a little bit out, they let a little bit more out, and as I've mentioned many times, they finished the last one with, well, as the night progressed, more information will be provided on his whereabouts once we receive discovery. And I have held strong on that, and I've wanted the rest of the information on the whereabouts as the night progressed. But now when you think about it, if she had put that information out there before now, guess what happens? Anything you say and do will be used against you in a court of law. An alibi is basically you making a statement. So that statement would then be able to be used against you at trial. Well, since she never progressed in that statement, that can't be used against him. Now, if the other evidence that they're looking to get suppressed is suppressed, there would be no reason to give the rest of the alibi and put yourself even in the area when it's not necessary to do. You see, if he gets the evidence suppressed from the AT&T warrants, from the Amazon warrant, from all of those warrants, that eliminates any phone records, text messages, cache data. It removes it all. All the prosecution could go to trial with at that point would be, guess what? We have a few videos of a car that looks similar to his that's in an area that we have no idea if he was even at. And that's it. Because the DNA is going to be, in my humble opinion, suppressed. And it tells me, again, everything I need to know, because they're not specifically arguing about suppressing the buccal swabs. What they're arguing about suppressing is the IgG. Now, you've got to think deeply now. But if they're focusing on suppressing the IgG, then that should let you know that the buccal swab was somehow tied in to the IgG, not an STR sample. Why do I say that? Because you can't start this case from today and start applying just what you hear today. This case has been going on for 2 years. What has been openly stated in court and in court documents by the prosecution? The IgG will never be presented at court, according to the prosecution in open court and in their filings. So, would it really be necessary to go and suppress IgG information, folks? It's already stated it's not going to be used at trial, and it can't be used at trial. So why would you go and suppress the IgG information so that it couldn't be used at trial? You wouldn't. You're suppressing with the IgG the fact that the DNA sample from the buccal swab was tied into it. That's why when they filed the warrant for Kohberger's arrest, Blaker specifically said, we do not want to use the DNA as any type of evidence in this warrant that we are obtaining to arrest Bryan Kohberger. Leave the DNA out. There's a supplemental form that we did do an IgG and all of this DNA stuff, but leave it separate. They did that because they knew that DNA would never make it into court. And they didn't want to lose all of their warrants due to citing that DNA as part of the evidence. That is coming back to bite them right now, folks. And last but not least, before we get into this, when I listened to that Moron last night talk about the times that if Kohberger did it, he would actually be going into the house and coming out of the house and driving away, even on his own assertion, he says Kohberger couldn't have made it into the house until 4:09, and he was seen on camera speeding away at 4:20. Yet, the law enforcement states that the atrocity starts between 4 and ends at either 4:25 or even extended out by the prosecution in court documents to 4:30. So the likely time of the atrocity is between 4 and 4:25, the original, or updated since then, 4 and 4:30. His moronic statement was, well, they want to give it a little extra time before and after, just to be safe. Idiot. You see, they're not going to extend out the time of the atrocity if they have concrete evidence of when it would have started and when it would have ended. We know from video evidence that if that is Bryan Kohberger's car, it was seen still driving at 4:07. And they state in their own paperwork that it was seen speeding out at 4:20. So if you have any common sense to you whatsoever, you would know that if they were stating that Bryan Kohberger was the only perpetrator in the atrocity, then at the very least, they would state that the crime happened between 4:07, where they last see the vehicle driving on video, and 4:20, where the vehicle is seen driving out of the neighborhood on video. They would not add an extra 10 minutes before and 5 to 10 minutes after, because they have video evidence with timestamps. By adding additional time, it would just create doubt. So that tells you, and also as you read their statements, they're saying that starting at 4 a.m., Mortensen is awakened and here's what she thinks is Kaylee playing with her dog. A few minutes later, hear somebody say something to the effect of, hey, there's somebody here. You see, they've already got activity going on in the residence related to the atrocity at 4 a.m., not 4:10. So it tells you one of two things. Either Kohberger had absolutely nothing to do with it, or the guy driving in the Elantra at 4:07 and driving off at 4:20 had absolutely nothing to do with it, or they're saying he was an accomplice because somebody would have been creating activity from 4 to 4:10 and creating activity from 4:20 to 4:25 or 4:30, other than the person driving the Elantra. So either he had nothing to do with it, or they're accusing him of being an accomplice. When you look at how they have everything written with the timeline, they're accusing him of being an accomplice. It is my contention, through much investigative effort and corroboration, that he had absolutely nothing to do with it. And I believe I can prove that. And I got it coming to you. But to hear a moron add extra time to an event and say that's, well, they just want to make it a little before and a little after. Man, go stare at sunsets, guy. Go read books to people in the nursing home. That would be much better served for you because you're a moron. But with all that being said, and I hate to be negative, there's so many good folks out there doing good things. But in this one, we're going to break down the Amazon warrant. And what I want to do is show you, in Ann Taylor's words, number one, why they want the information in the Amazon warrant suppressed. It's not because he bought a K-bar. God, calm down. I was going to do this one calm. It's not because he purchased a K-bar, and I'll show you that. So I'm going to show you why they wanted the information suppressed. And then I'm going to show you the 3 separate arguments that they're making for the motion to suppress. And in those arguments, I will show you how everybody thinks the IGG is the argument. I'm going to show you how that is one argument. And it's completely separate from the other two. And it is a minor argument as it relates to the Franks motion. And I'm going to show you that in this. And I'm also going to show you where this is all revolving around a confidential informant. And it ain't the IGG. For the last time, read the Steve G texts. He was going to meet the confidential informant at a hotel. Can you meet an IGG at a hotel and the FBI stop you? Whew. Let's get into it. This is going to open your eyes, I assure you. Here we have the Amazon warrant. Motion to suppress for Amazon account. Federal grand jury subpoenas and warrants dated April 26th and May 8th. So grand jury subpoenas, that's federal grand jury right there. So they want the subpoenas suppressed and the warrants. And then it discussed the issues and the facts. We're going to skip on down here though. And we got the argument right here that Mr. Kohberger is making. And when we come down here, I want to focus in on this part. Because when you hear these people out there saying that the reason that they want the Amazon warrant suppressed is because of the K-bar knife purchase. Well, that is ridiculous. So let's focus in here. And it says, and then by the way, this is why the defense wants to suppress the Amazon warrant. This case is not about bank records, but purchase records from an online company. So this is a key statement. It's not about bank records, but purchase records from an online company. You see, that is what the state cited in their warrant for the Amazon account, is they wanted purchase records. So the other information that they received other than purchase records would not even be relevant, would they? From the standpoint of the Fourth Amendment, one's behavior with Amazon can provide a massive amount of information about a person's private life. So the warrant was for purchasing records, but what law enforcement actually got from the warrant was much more than purchasing records. Hence why the need for suppression. You see, your name, address, searches, and recordings when you speak to the Alexa voice assistant, it knows your orders, content you watch on Prime, your contacts if you upload them. They want to know who you're talking to, and communications with it via email. But it can reveal a lot about you. From this information, Amazon can work out where you work, where you live, how you spend your leisure time, and who your family and friends are. Prime Video and Fire TV, if you recall, in the search of his apartment, they got a Fire TV stick. And that's what you plug into your TV to be able to watch things, and it's an Amazon device. So it contains information about what you watch and listen to. And it can reveal your politics, religion, culture, economic status, says Fielding, with third parties. But it makes no such commitment about other type of photo data, such as geolocation tags and device information, or attributes of people and objects featured in images. Because Amazon promises not to share facial recognition data with third parties. But the information that they got from Amazon would give you so many different data points that you could cherry pick from when painting this circumstantial case against Kohberger, that it would be so easy to paint the picture you wanted to paint. You could do it to anybody. So all of this information would be very valuable to the prosecution painting a circumstantial case, because they don't have any real evidence to focus in on. It has absolutely nothing to do with buying a K-bar. What you read, when you read it, how fast you read it, what you've highlighted and book genres. Remember, they in the search for his parents' house, they found a book in his room on page 118. They noted an underlined statement. So anything that you've read through Kindle, if you've highlighted or underlined anything, that can be used as circumstantial evidence against you. They forget the fact that this guy has been a criminology major for, 8 years? Of course he's going to read and highlight in strange things about criminal activity in books. But they will use all of that against him at trial. And all they have to do is bring it up and paint a picture. Even if the defense has an argument like I just said to counter it, it still puts that in the jury's minds. If they don't have that information to be able to put in the jury's minds, then they can't put it in there. So yeah, they would really want this information to be suppressed. And then there's this very important part. It can add up to a lot of data, Amazon spokesperson says, about the thoughtful information they collect. So when you look at the discovery presented to the defense from the prosecution and you talk about 50 terabytes, where were those terabytes of information? I'm sure a lot of it was from pointless videos that they collected, hours and hours of it, except for the ones that wasn't pointless. They didn't find those after they collected them. They lost them. But a major source of those terabytes of discovery, you can bet, is all of this type of information they got from Amazon and Google and Apple and all of those sources. So just getting it suppressed based on the fact that they can't possibly go through all this information before trial would be a huge hand in the defense not having to come up with reasons to defend things, because they can't even view it all. So that's why they want the Amazon warrant suppressed, not because he purchased a K-bar knife like morons out there keep saying. But now let's get into this really key part, because this is regarding the legal arguments, why it should be suppressed. And their first legal argument was basically all on privacy. And that's a general argument based on a person's right to privacy. So the first argument was privacy, nothing with specific details as it relates to this case. But this second argument is a key argument, and there is some key details in this one that please follow me closely on this one, and it will help you to understand this entire case. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Okay, now this is the second argument, completely separate argument than the first and the third. The first we just talked about on privacy, and the third argument. So this is the argument that recklessly or intentionally omitted material information. Now, what did we learn about what a Frank's motion is about? A Franks hearing is a legal proceeding that challenges the validity of a search warrant by questioning the truthfulness of the statements in the affidavit used to obtain it. The hearing is named after the landmark case Franks versus Delaware, which established the legal standard for challenging search warrants. Now, the evidence that the defendant can use as evidence, such as witness testimony or documentary evidence, to prove that the affidavit statements are inaccurate. So the defendant can use either witness testimony or documentary evidence. So what kind of document could it be that the defense wants to present to the court in the Franks hearing to prove that the truthfulness of the statements of law enforcement was not there when obtaining the warrants for Mr. Kohberger? Now, I've listened to a lot of the attorneys out there. I like the lawyer, because he says it the most honest way. He says we cannot know what is in the proffer because it could be so many different things. And he's right about that. However, I believe you can garner what the proffer is about by reading the argument related to this portion of the motion to suppress. And remember, a proffer is the prelude to cooperation. The individual is under investigation or has been charged with a crime and wants to offer information to law enforcement authorities in exchange for some benefit, such as drop to reduce charges or an agreement for a lower sentence. That agreement is known, in other words, as a contract for a lower sentence. Keep that in mind as we progress through this motion to suppress. So again, this is argument number 2. There's 3 completely different arguments in these motions, or in this one specifically, to request suppression of this evidence. And this one alone is the affidavit submitted in support of the application for the issued search warrant, recklessly or intentionally omitted material information. And you can see down here, I've highlighted any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression. And again, they were looking for a knife purchase in this warrant. So since the knife purchase was sought, but other information gathered tells us there was no finding of the knife purchase. And they're wanting it suppressed because of the other information that was gathered that we just discussed. But then down here, it gets into the most telling part of this. And that is the fact that she cites State versus Peterson. 133 Idaho 4447. And she puts in her argument that intentional or reckless falsehoods, and remember the title of this argument up here, recklessly or intentionally omitted material information. So, intentional or reckless or intentional falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. Again, cites Peterson. So the whole basis of this argument is what was intentionally or recklessly or deliberately or recklessly omitted from obtaining the warrant in their probable cause affidavit for the warrant. Not to be confused with the probable cause affidavit for, the arrest. So again, she cites Peterson. See State versus Peterson. I also have in here an interesting note, the Quad Cities Drug Task Force statement by Brock Germer, because they both relate so perfectly to this argument. What was intentional or reckless? Let's look at State versus Peterson. State versus Peterson, 133 Idaho 4447 is a case that discusses the following topics. The veracity of an affidavit. A criminal defendant can challenge the veracity of an affidavit used to obtain a search warrant. Reliability of a confidential informant. When a confidential informant is involved in the criminal activity, more information is required to establish their reliability and veracity. When a confidential informant is involved in the criminal activity, or you can say a criminal activity as well. So you can't have an IGG involved in a criminal activity. It's impossible. Treating an informant as anonymous. An informant whose identity is known to the police is not to be treated as an anonymous tipster, even if their name is not disclosed to the magistrate. That means they have to name the confidential informant. They cannot treat them as an anonymous tipster. And I think this is just priceless. This is Bryan Kohberger's statement to the press about how the Quad Cities Drug Task Force operates. And look at these statements. Arrested individuals might have the opportunity to work as a confidential informant. They might have the opportunity, like it's a good job or something, to work as a confidential informant under contract. What did we just talk about with the proffer in the contract, the agreement? He said the contract, the agreement, because of the proffer, will depend on the severity of their crime. He said there is a challenge of established reliability and credibility, as the task force is reliant on the informant. So even in their statements to the press, they cite the fact that the informants have a contract and there is a challenge establishing their reliability and credibility. And this is as it relates to drugs. So can you imagine the challenge to establish the reliability and credibility of an informant involved in drug transactions informing on Mr. Kohberger in this case? That is what this all means, folks. So that argument, see State versus Peterson, I just showed you the excerpt from the media statement to the Quad Cities Drug Task Force. That is the main argument she's making in part 2 of this. But watch. In this case, meaning the Kohberger case, law enforcement either intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. The proffer required for a Franks hearing is filed contemporaneously under seal. The proffer asserted applies here. Now, I want you to stop and think about this statement for just a minute, because this argument in this motion has nothing to do with the IGG, folks. The IGG I'm going to read to you here on the third argument. This argument is completely separate from the IGG. See, in this case, law enforcement either intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. The proffer required for the Franks hearing is filed contemporaneously under seal. The proffer asserted applies here in this motion that doesn't have anything to do with the IGG. That's what the Franks hearing is for. It's not for the the IGG, although the IGG I'm sure will be used also in the Franks hearing because they're going to prove that the IGG wasn't real anyways. Now, here is the third argument in this, and that's how you know it's different. Because the affidavit submitted in support of the application for the issued search warrant included information that must be excised. So, the information that they put in the third warrant must be excised. Why? Because all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. This is the third argument. It needs to be excised because of an unconstitutional use of investigative genetic genealogy, not because the genetic genealogy intentionally or recklessly omitted exculpatory evidence. And that's why the Franks hearing is being called into question. No, this is an entirely different argument based on unconstitutional use of the IGG. If that doesn't prove to you the confidential informant angle of this case, I don't know what will. You can see it says Mr. Kohberger has argued in a separate motion, that the genetic genealogy investigation in this matter was done in violation of the Constitution. That is a completely separate motion, he argued, about the constitutionality of the investigative genetic genealogy, not the Franks motion. Because the warrant, this is their final conclusion, because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, this is argument number 2. It omitted exculpatory information and information that put into question the reliability of the facts upon which it relies. They omitted the fact that there was a confidential informant, and because they omitted it, it put into question their ability to check the reliability of that confidential informant. Now, again, watch this. And that means two different things right here. And finally, because the affidavit relied on evidence gained in violation of the Constitution. Violation of the Constitution, separate motion, unconstitutional use of investigative genetic genealogy. They're two separate arguments. There's a confidential informant. If that doesn't prove it for you, then I don't know what else I can do. I mean, I can go up there and get that confidential informant and drag his butt down to the city square and make him talk, but I can't go that far. And there you have it. Heck, I'm through 3 of these things now. I'm fighting an uphill battle as I watch YouTube out there and the reactions to people. Heck, I watched one the other night, and I realized how easily people are led astray. It was one of those, where they have the little panel of people on there, and this guy, they're talking about, of course, they're talking about, my information, of course. I'm always the hot topic out there, it seems. But they said, they were talking about, and I don't even like bringing it up, but they were talking about the mama's involvement in the motive. And 2 of the people on this guy's panel were obvious believers in my theory. And this guy says, I don't believe that because, she was being witness protection right now. They wouldn't release her early. Give me a break. The fact that they already released her prior to the end of the rider date should tell you everything you need to know. But what's weird is those two other people on the panel that quickly went, yeah, I agree with you. It's the, and then he went on to, I'm going to stay with what I know with the frat boys. And they're like, yeah, it's frat boys. I'm like, good grief. People are easily led astray by morons. But I'm going to keep it real, and I'm going to keep it going, and I'm going to keep uncovering. And I've got this thing pretty much nailed, folks. I'm working on a long form video that explains exactly what happened at the atrocity. I mean, detail by detail, because I believe I've got it now. But please like and subscribe to the channel. Post your comments, thoughts, criticisms. Until next time, got 9 more motions to go through. Pavarotti's out.